Good morning and welcome to another edition of Law Talks here on 4CRB. Well, one of the most challenging aspects of separation can be dividing up finances, particularly if one person isn't being completely upfront about what they own or earn. From undisclosed bank accounts to cryptocurrency and hidden income, these situations can make an already stressful process even more complicated. To explain how this works and what people can do to protect themselves, we're joined by Attwood Marshall Lawyers Family Law Associate Breanna Farrell. Thanks for joining us, Breanna.
Oh, you're welcome. Thank you for having me here today.
Well, Breanna, when couples separate, what are their legal obligations when it comes to disclosing their financial position?
The court is very clear in terms of a party's duty to provide full and frank financial disclosure. When couples separate, there is this statutory duty of parties to disclose everything.
Yeah.
So that is often in the terms of 12 months of bank statements for all accounts held, including things such as liabilities or short-term loans like Afterpay, Zip Pay, if they're a beneficiary of a trust and there's any trust income in relation to that as a financial resource. The overarching obligation is that it's better to over-disclose a party's assets and liabilities and financial position than under-disclose.
And be caught out.
Absolutely.
All right. So I imagine you see it all, but what kinds of things do you commonly see people try to hide during a separation or divorce?
One thing I'm very privy to being a family law solicitor is the very creative ways people can try and hide their assets, including withdrawing small amounts of cash on a regular basis here and there, which over time can accumulate to a significant amount. You will sometimes see parties try and fund investments that will ultimately be cashed out later, one creative thing I have seen is quote unquote gambling monies. So a party will go in, extract huge amounts of money and try and say that they lost it while gambling. And it can be very tricky to claw those funds back.
Okay, modern assets like cryptocurrency or online investment accounts making it more difficult to identify what someone owns, or are they actually easier to trace than people might think?
They can be easier to trace than people might think. Because you have a duty to provide full and frank disclosure, including bank statements, you're actually ordinarily going straight to the source. And all it really takes is a simple financial tracing exercise where you can actually have a look at those transactions and really follow where that money is going.
Yeah. Okay. And if someone suspects their former partner isn't being completely upfront, how do lawyers go about uncovering assets that haven't been disclosed?
If the matter is already before the court and litigation has commenced, we can use tools such as subpoenas to uncover hidden bank accounts or other assets that a party has not disclosed or failed to disclose.
And what are the consequences if someone is caught deliberately hiding assets or failing to properly disclose their financial position?
I can tell you guys that the courts do not take kindly to parties where they deliberately fail to disclose and adhere to their duties. And it really comes under the umbrella of being fundamentally dishonest.
Okay.
And so the court may make inferences as to what assets a party has or doesn't have based on their non-disclosure of those particular assets. And there are mechanisms in place throughout the litigation process. For example, one might, if a party has gone to the expense of having to issue subpoenas, one party might seek costs for having to go to that extent.
Yeah, okay. All right. And can that kind of behaviour change the outcome of the property settlement?
Absolutely. If a party is found to be deliberately dishonest and a court is making a decision based on the inferences of that disclosure or non-disclosure, it can have a significant impact on the overall adjustment.
And what steps can people take early on to protect themselves and make sure everything is being properly accounted for?
That's such a good question. I often have this conversation with my clients early before proceedings are initiated. And my initial advice is ask questions. Ask questions of your accountants and really get an understanding. If you're a joint signatory or you are also named on the account, you have the ability to go directly to that bank and seek copies of those statements yourself, even if you don't have access to the app or online. It's really important that you take steps to understand what you and your spouse have purchased throughout the relationship.
Okay, Breanna, that's all we have time for today. So seeking early advice can make a big difference if there are concerns about undisclosed assets.
Absolutely.
Thanks for your time today.
Thank you.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.